Pelican Bay versus ADX Florence. What isolation really means. The tray came back full for the 11th consecutive day. Not partially eaten. Not picked over. Untouched. Returned through the slot in the door exactly as it had been delivered, the food cold and undisturbed. Stay with this story, because what the meal logs revealed next had been sitting in plain sight for longer than anyone in the administration wanted to acknowledge. ADX Florence sits in the high desert of Fremont County, Colorado. It is the only federal supermax prison in the United States. It holds approximately 400 inmates, the most dangerous, the most escape-prone, the most operationally complex cases in the entire federal system. Each inmate spends between 22 and 24 hours per day inside a 7 by 12-foot concrete cell. Meals are delivered through a slot in the solid steel door. Human contact is minimal by institutional design. The facility was built on the premise that maximum physical separation produces maximum security. What it produces in the human beings inside those cells is a question the institution has been slower to answer. Dr. Marcus Webb was a contracted forensic psychologist assigned to ADX Florence in the spring of 2019. His role was not clinical treatment. It was assessment, periodic mental health evaluations of the general population submitted to the Bureau of Prisons as part of a court-mandated monitoring program that had emerged from a 2012 class action settlement. He had been doing this work for 11 years across multiple federal facilities. ADX was different, not in the way administrators described it in official communications, controlled, structured, operationally sound. Different in a way that accumulated across weeks of assessment interviews and revealed itself not in what the inmates said but in what the meal logs showed when Webb started reading them alongside his clinical notes. The meal refusal data had not been flagged by the facility. Webb discovered it by accident, during a records request for a different purpose entirely. He had asked for the medical contact logs for a subset of inmates he had recently assessed, standard procedure for cross-referencing clinical observations with healthcare utilization patterns. The meal logs came with the medical files as part of the same administrative bundle. He almost didn't look at them. When he did, the pattern was immediate. Across a 90-day window, 34 inmates in the facility's most restrictive housing unit, the H unit, where sensory contact with the outside world was reduced to its absolute institutional minimum, had recorded meal refusal rates of 60% or higher. 60%. More than half of all meals delivered returned untouched. The medical files showed no corresponding increase in documented nutritional intervention. No feeding protocols initiated. No formal malnutrition assessments recorded. The meals were being returned. The returns were being logged. Nothing was being done with the data. Webb pulled the meal refusal logs for the previous 12 months. The pattern was not new. It had been present, at varying intensity, across the entire year. In some months the refusal rate across H unit had reached 70%. Nobody had connected the meal logs to the medical files. The two record systems operated in separate departments with no automated cross-reference requirement. Nobody had been looking at both at once. He requested the equivalent records from Pelican Bay State Prison in Crescent City, California, the state-level supermax facility that had been at the center of a landmark hunger strike in 2011 involving over 6,500 inmates across the California prison system. The Pelican Bay records, obtained through a research data sharing agreement, told a different story from the same starting point. The meal refusal rates were comparable. The population profiles were comparable. The physical isolation conditions were comparable. But one column in the Pelican Bay data showed a figure that did not appear anywhere in the ADX records. A documented clinical intervention rate. At Pelican Bay, meal refusals above a defined threshold triggered an automatic clinical review. The review was documented, time-stamped, and entered into a centralized monitoring system that both the medical and custody departments could access simultaneously. At ADX Florence, no equivalent protocol existed. The meal refusals were being logged into a system that had no mechanism to act on what it recorded. But when Webb cross-referenced the H-unit refusal data against the facility's own internal security incident reports for the same 90-day period, everything changed. The security incident reports were not classified. They were internal administrative documents, accessible to contracted clinical staff under the terms of Webb's assessment agreement. He had never requested them before. His work had not required it. It required it now. What the H-Unit security incident reports showed across the same 90-day window was a 34% increase in what the Bureau of Prisons' internal classification system called behavioral incidents, a category that covered a defined range of in-cell behaviors serious enough to require a documented custody response. 34%. The meal refusal rate and the behavioral incident rate had risen in parallel across the same 90-day period. The correlation was not subtle. It was consistent across every month in the window, with both rates peaking in the same 2-week period in the middle of the quarter. Nobody had placed the two datasets side by side before Webb did. They were maintained in separate systems, reviewed by separate departments, evaluated against separate compliance metrics. The pattern they formed together was invisible to anyone looking at only one of them. Webb prepared a formal clinical observation memo. Standard format. 6 pages. Every claim referenced to a specific document and a specific date range. He submitted it to the facility's clinical director on a Tuesday morning. The clinical director acknowledged receipt the same day. His response arrived 4 days later. It noted that meal refusal in the supermax population was a documented behavioral phenomenon with a substantial research literature. It noted that the existing medical monitoring protocols were compliant with Bureau of Prisons Program Statement 6031.04 on patient care. It noted that the correlation Webb had identified between meal refusal rates and behavioral incident rates, while noted, did not constitute a clinical emergency under the applicable federal standard and therefore did not trigger a mandatory protocol review. The response was courteous, precise, entirely within its institutional framework. It did not address the absence of an automatic clinical intervention threshold. It did not address the 12-month historical pattern Webb had documented. It closed by thanking him for his continued diligence. Webb sat with the response for 2 days. He was not new to institutional resistance. 11 years of contracted forensic work had given him a precise understanding of where formal clinical authority ended and institutional discretion began. He knew the difference between a system that was failing and a system that was functioning exactly as designed, and producing outcomes that the design had not adequately considered. What he was looking at was the second kind. The Bureau of Prisons Program Statement 6031.04 that the clinical director had cited was a document Webb knew well. He pulled it and read the relevant provisions again. The statement required medical monitoring of inmates who refused meals. It defined the monitoring protocol in terms of observation frequency and documentation requirements. It specified the threshold at which a formal malnutrition assessment became mandatory. What it did not specify was any requirement that meal refusal data be systematically reviewed in conjunction with behavioral or psychological incident data. The two streams of information about the same human being in the same cell were permitted, by the governing program statement, to remain permanently separate. The protocol was not missing from the facility. It was missing from the federal standard. Webb expanded his research scope. He contacted 3 academic colleagues who had published peer-reviewed work on solitary confinement health outcomes. He requested their unpublished data sets alongside their published findings. What came back over the following 2 weeks confirmed the pattern he had identified at ADX and extended it. Across 7 supermax and extended isolation facilities studied between 2010 and 2018, meal refusal rates in the most restrictive housing units showed a consistent correlation with documented psychological deterioration markers. In every facility where an automatic clinical cross-reference protocol existed, Pelican Bay being the most developed example, the deterioration curve was measurably flatter. Early intervention, triggered by meal refusal data, demonstrably changed outcomes. In facilities without the protocol, the curve was steeper. The outcomes were worse. The difference was not resources. The difference was not staffing levels. The difference was a single procedural requirement, whether the meal refusal log and the clinical assessment system were required to talk to each other. At ADX Florence, they were not. He requested a meeting with the facility warden. The meeting was scheduled, postponed twice, and eventually conducted via telephone rather than in person. The warden's position was consistent with the clinical director's. Existing protocols met federal standards, the facility was in compliance, and any proposed protocol changes would need to be evaluated through the Bureau of Prisons' Central Policy Review process, a process that operated on an 18 to 24-month cycle. 18 to 24 months. Webb asked what happened to the inmates in H Unit during those 18 to 24 months. The warden noted that the existing monitoring protocols remained in effect throughout any policy review period. The call ended. Webb made a decision that fell outside his contracted scope but within his professional obligations as a licensed forensic psychologist. He filed a formal report with the Bureau of Prisons' Office of the Inspector General. The report was 22 pages. It included the 90-day meal refusal data, the 12-month historical pattern, the behavioral incident correlation, the Pelican Bay comparison, and the academic research synthesis. It included the clinical director's response and the warden's telephone position. It included a single specific recommendation, a mandatory cross-reference requirement between meal refusal logs and clinical assessment systems in all federal facilities operating extended isolation housing units. One requirement, precisely defined, already demonstrated to produce measurably better outcomes at the state level. The OIG acknowledged receipt within 72 hours. Then Webb received something he had not expected. A call from a former ADX staff member who had left the facility 14 months earlier. What that person told him about the meal log system, specifically about how refusal data had been recorded and what had happened to certain entries before they reached the administrative file Webb had been given, changed the nature of everything he had submitted. The former staff member's name was never made public. In Webb's OIG supplemental filing, submitted 9 days after the initial report, the source was identified only as a former ADX Florence correctional employee with direct operational knowledge of the H-Unit meal delivery and logging procedures. The source had left the facility voluntarily in early 2018 and had not been subject to any disciplinary action during their tenure. They had been waiting for someone to ask the right questions. Webb had asked them without knowing it. What the source described was not a conspiracy. It was something more institutionally familiar and, in its own way, more difficult to address. A practice. Informal. Unwritten. Passed between staff during shift handovers without documentation, without authorization, and without any record that it had ever existed. When an inmate in H-Unit refused meals for an extended consecutive period, the threshold the source described was approximately 7 to 10 days. The logging procedure changed. Rather than recording each individual refusal as a discrete entry, the log would reflect the period as a single notation: meal delivery completed. The food had been delivered. The slot had been opened. The tray had been passed through. Whether it had been accepted or returned was not always reflected in the individual entry. The practice had developed, the source explained, not from malice but from operational pressure. Consecutive meal refusal entries in a single inmate's log triggered an administrative review requirement, a paper-intensive process that fell on the custody officer completing the shift log. In a unit where staffing levels were consistently below the posted complement, that administrative burden had been informally redistributed into a recording shortcut that eliminated the trigger. The review requirement disappeared because the data that activated it was no longer being accurately captured. Webb read his own 90-day dataset again with this information in place. The 60% meal refusal rate he had documented, the figure that had driven his original memo, his OIG filing, and his academic research synthesis, was not an undercount of a hidden problem. It was an overcount of what the modified logging practice had failed to obscure. The actual refusal rate, reconstructed from the source's account of the threshold at which the logging change occurred, was higher. Significantly higher. The data Webb had been given, the data the facility's administrative system had produced, had already been filtered through a practice designed to prevent the administrative consequences of accurate recording. What he had identified as a pattern was the pattern that had survived the filter. The OIG supplemental filing was received and assigned to an investigative officer within the Bureau of Prisons Oversight Division. The investigation ran for 11 months. Its findings, released in a summary form in late 2020, confirmed the existence of the informal logging practice in HUnit. The investigation determined that the practice had been in use for a period of at least 3 years prior to Webb's original data request. It determined that the practice had not been sanctioned by facility administration and that no documentation of its existence existed in any official record. The investigation could not determine with precision how many individual meal refusals had been recorded as completed deliveries during the 3-year period. The source data that would have allowed that calculation no longer existed in recoverable form. The actual scale of what had been happening inside HUnit, how many consecutive refusals, across how many inmates, over how many months, could not be established from the available record. It could only be estimated. And the estimates, based on the logging threshold the source had described, were troubling enough that the OIG summary noted them without publishing the figures. The corrective actions that followed were specific and documented. The informal logging practice was formally prohibited through a facility-wide administrative directive. A standardized meal refusal recording protocol was introduced, requiring individual entry for each refused meal regardless of consecutive duration. An automatic clinical cross-reference requirement, the single procedural change Webb had recommended in his original filing, was introduced at ADX Florence as a facility-level policy pending Bureau-wide review. The Bureau-wide review of Program Statement 6031.04 was initiated in early 2021. Its findings, when published, recommended the cross-reference requirement be adopted as a mandatory standard across all federal facilities operating extended isolation housing units. The recommendation was incorporated into a revised program statement issued in 2022. At Pelican Bay, the automatic clinical intervention protocol that Webb had identified in his original comparison had been in place since 2014. Introduced in the aftermath of the 2011 hunger strike as part of a negotiated reform package between the California Department of Corrections and Rehabilitation and inmate representatives. It had taken a hunger strike involving 6,500 people across the California prison system to produce a procedural change at the state level. It had taken one contracted forensic psychologist reading a meal log dataset he had almost not looked at to produce the equivalent change at the federal level. The outcome was the same. The path to it was not. ADX Florence continues to operate as the only federal supermax prison in the United States. The revised logging protocol is in effect. The clinical cross-reference requirement is in effect. The program statement revision is published and binding. By every current metric, the system that existed when Webb arrived in 2019 has been corrected. What cannot be corrected is the 3-year period during which the informal logging practice operated without detection. The inmates whose consecutive meal refusals were recorded as completed deliveries during that period received no automatic clinical review. What they experienced, medically, psychologically, in the specific and cumulative way that extended isolation and inadequate nutrition interact in the human body, exists outside the recoverable record. The institution knows what its protocols now require. It does not know, and cannot now establish, what its previous protocols failed to provide. That gap, between what the paperwork recorded and what was actually happening inside those cells, is not a gap that a revised program statement can close retroactively. It can only be kept from widening further. Whether it stays closed depends entirely on whether the next person who receives an administrative data bundle takes the time, as Webb did, to read a file they were not specifically asked to read. The meal logs are still being filed every day. Someone still has to look at them. If this story stayed with you, the next one goes further, and the records are even harder to find.